Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And this is my private Facebook group, and if you are in foreclosure or about to be in foreclosure, or maybe you've gone through it and you want to be with other like-minded people, you can join my private group. And we help each other on this page. And welcome to my YouTube channel, and thank you for subscribing or hitting that like button. It helps. Today we're going to talk about an important development in one of our foreclosure fighters, Kahara Passmore, out of Virginia. And there's been a break on her case. If you're in Pacer, you can look at it up in Pacer. It's 125CV00524. Passmore versus Pentagon Federal Credit Union, or PenFed. And you can see that the judges are listed right there. And you can see she filed her complaint in, it was on 3/26/25. And the last filing was 1/23/26, which was a few days ago. But let's get into what's going on with her situation now. She filed an amended complaint at the order of the judge. And let's go to the end and go backwards. It'd be easier. So she had a default judgment against her, against PenFed and the other two entities, Equity Trustees and BWW Law Group. And you can see here, you'll see that there was a motion for a default judgment here, memorandum in support, declaration, there was a hearing, and at the very last thing here, docket number 66 on 1/23/26 is an order. And that order is what we're going to be looking at, because the judge slammed the bank's attorney. Mr. Michael is the attorney for the defendants. And so she slammed them with this order threatening sanctions. Isn't that wonderful? So let's take a look and see what happened on this order. Go to the top here. Okay, so this order says this matter before the court on its own initiative to address the conduct of defense counsel. On August 20th, 2025, attorney Robert Michael entered an appearance on this matter on behalf of defendants BWW Law Group, LLC, and Equity Trustees, LLC. Mr. Michael filed a motion to dismiss on behalf of those defendants, but failed to notice or waive a hearing date as required by the local rule. Local rule says the moving party shall be responsible to set the motion for hearing or arrange with opposing counsel for submission of the motion without oral argument. On October 21st, 2025, the clerk issued a notice of correction instructing Mr. Michael to file a notice of hearing. Mr. Michael never did so. See Local Rule 7E. Unless otherwise ordered, a motion shall be deemed withdrawn if the movant does not set it for hearing or arrange to submit it without a hearing within 30 days after the date on which the motion is filed. In any case, that motion to dismiss was mooted by plaintiffs filing a second amended complaint, which was docket number 50. On October 16, 2026, the court ordered that defendants file any answer or responsive pleading with respect to the second amended complaint by Thursday, November 6, 2025. Mr. Michael failed to file a responsive pleading as directed and has not since sought leave to file a responsive pleading out of time. Plaintiffs requested entry of default against Mr. Michael's clients, defendant BWW Law Group, LLC, and Equity Trustees, LLC, and the clerk entered default against them. Plaintiff then filed the motion for default judgment against defendants BWW Law Group and Equity Trustees. The court held a hearing on that motion on January 23, 2026. At no point did Mr. Michael file a response to the motion for default judgment or move to set aside default. During the January 23, 2026 hearing, plaintiff presented argument. As the hearing was about to conclude, Mr. Michael entered the courtroom. The undersigned asked Mr. Michael why he failed to file anything in this case since August of 2025, and he responded that he was under the impression that the motion to dismiss was pending review and there had been no other activity on the docket. When the court inquired about his failure to abide by the October 16, 2025 order and to respond to plaintiff's motion for default judgment against his clients, Mr. Michael responded that he had not seen the respective electronic notifications for those filings, and he was unaware that January 23, 2026 hearing had been scheduled. That's a poor excuse, isn't it? Relatedly, when Mr. Michael previously appeared before the undersigned at a hearing on September 12, 2025, Mr. Michael presented that he anticipated he would be engaged to represent the third defendant in this action, which was Pentagon Federal Credit Union, or PenFed. Once plaintiff properly served PenFed. On September 23, 2025, plaintiff filed an executed summons reflecting that she had served PenFed's registered agent, yet no attorney has entered an appearance on behalf of PenFed in this action. The clerk has since entered default against PenFed, and on December 19, 2025, the court held a hearing on plaintiff's motion for default judgment against PenFed. During the January 23, 2026 hearing, the undersigned summarized the sequence of events and asked Mr. Michael why PenFed remained without representation. He responded that he was not aware of whether PenFed had been served, despite the fact that the docket reflects the proof of service, entry of default, and motion for default judgment concerning PenFed. Mr. Michael further stated that he had not been engaged as PenFed's counsel for this action. Accordingly, it is hereby ordered that Mr. Michael file a pleading on or before January 30th, 2026 concerning whether sanctions should be imposed or disciplinary action should be taken against him given the conduct described herein. Any briefing should specifically address 1. Why no responsive pleading was filed in accordance with the October 16, 2025 order, and 2. Why no opposition was filed in response to plaintiff's motion for default judgment against defendants BWW Law Group, LLC, and Equity Trustees, LLC, and why Mr. Michael claimed to not have notice of electronic or otherwise of the status of this case. The clerk's office is directed to mail a copy of this order to defendant Pentagon Federal Credit Union. Entered this 23rd day of January 2026, Lindsay Robinson Vala, United States Magistrate Judge. Okay, so that's what's interesting about this is you hardly ever see these kinds of things happening when the attorneys for the bank do this. They hardly ever get sanctioned or threatened sanctions, but this is good news for Kahara because, you know, she's going to probably get the default judgment, and the sanctions is kind of like a bonus, if you know what I mean. So everyone keep your fingers crossed for her to win this one. And as always, thank you for watching my channel, guys. If you have any questions regarding your own foreclosure situation, you can always email me. My email address is foreclosurehelp777@gmail.com. And as always, everyone have a blessed day.